And thereafterwards we go ahead with further propositions that a taxpayer on his own can pay the tax either on his own ascertainment beyond the time limit within which he ought to have paid the tax. The due date for filing return, the due date for payment of taxes for a time of supply provisions, all of you are aware that if he on his own has identified that there is a short levy, non-levy, or erroneous claim of refund, or irregular availment or utilization of credit, even without issue of a notice by a proper officer, he can go ahead and make good that payment along with interest. So he can communicate to the tax officer that I have paid this short payment of tax or reverse the irregular input tax credit along with interest. And therefore, I am communicating to you this, I have done it. So even though there is a short payment, non-payment or erroneous refund, the proper officer is precluded from issuing a show cause notice in such cases. If during the adjudication process you come across the evidence advanced by a taxpayer in response to your show cause notice that this payment has been made by me on my own volition and communicated to the department officer much before the department issued a notice to me, you ought to take note of those submissions and validate it with regard to evidences whatever is submit and accordingly pass a fair and judicious order. Because the word used in section 73 is where a tax and interest has been paid and that payment is not disputed in the notice, that means there is no short payment. Whatever is required to be paid, he has paid and will be paid in interest. The wording used in the show cause in the proceedings under 73 is that he shall not issue a notice. The word shall is mandatory, directory, and is obligatory on the part of the department not to issue a notice. If somebody has issued a notice, you simply have to drop. Now, the second part of that and 73 is that it can be that the proper officers also can point out a short levy, non-levy or erroneous refund. It could be through scrutiny, audit, investigation, or any of those third-party data, the analytical data what one of the panelists talked about in today's morning. So in such cases, probably we are all required under Rule 142A today to issue mandatorily a DRC 1A. The DRC 1A is a process by which we communicate a liability which a taxpayer need to meet with and communicate to him that this is what I have ascertained, and if you are willing to pay this tax along with interest and penalty wherever is applicable, you can do so and give a reasonable time limit within which the DRC 1A has to be met with a response. In the last 7 years of implementation of GST, we have come across a number of cases where either the DRC 1A was not issued, or for that matter, when DRC 1A was issued, very short time limit was given to the taxpayer to respond, or many a time the DRC 1A has not been issued. I am mindful of the fact that in 2019 there was an amendment was made. The word shall has been replaced with may for communicating. But as a good practice, all of us need to keep it in mind. Because there are compounding provisions available under law for a taxpayer to pay the tax, interest and the prescribed penalty and close the proceedings, it would be in the interest of fairness and just that the communicating the tax liability ascertained by the tax officer before a formal notice in the form of DRC-1 is issued is communicated to the taxpayer to meet with the response. Now this is very, very important. The pre-notice consultation which exists in the Central Excise Law by virtue of an executive instruction, the pre-notice consultation which is other than for suppression cases which is existing in the Customs Act, and in the GST law, whether it is for 74 or 73, the pre-notice consultation to be made for the taxpayer to meet with that liability by paying the tax and interest and wherever is applicable, should be a good practice followed. And if such a person has followed that, if it has been communicated, many a time what we see in adjudication is that quite often our officers do have this apprehension that what has been said in the response to the DRC 1A is most likely to be repeated to the reply to the show cause notice. There's no value in it. Plus, please be very aware of this procedural requirement. Why is the purpose of entirely a pre-notice consultation has been done? Because the law provides a mechanism by which the taxpayer can come forward and pay. It could be a full agreement, it could be a partial agreement. If there is a partial agreement, at least to that extent, the dispute need not survive. Collect the tax, collect the interest, collect the penalty applicable, and close the proceedings to that extent of agreement. And what is permitted for us to issue the notice is only what is not agreed upon, and for that notice has to be issued and adjudicated upon. This is very important. And GST law also says that you need to issue notice within the time limit prescribed and the overall time limit provided for. In normal period 3 years, and 3 months is the preceding period by which you have to issue a notice. Most of us would find today, we are talking about GST closing 7 years, and we are not talking about the demand for the year 17, 18, 18, 19 has already, normal period of demand is over. 18, 19 is also getting over, I think so. 19, 20 is also getting over shortly. And we are also aware that 5th August 2024 is the last date for issue of notice and extended period for 17-18. Now, while on one hand, as departmental officers would be hard pressed for time for issuing notices and adjudicating the demands, also mindful of the fact, that's because as we are talking about an adjudication workshop, it is very, very important to keep it in mind. An adjudication is nothing but a dispute resolution mechanism provided under the law. And there are fair principles of natural justice will have to be followed. What does the law say? If there is non-payment of tax, the liability is not only to make good the tax, but also pay 18% interest and over about the interest, the penalty. And all of us are talking about the indirect taxes. Indirect taxes, by their very design, the tax deductor or the tax registrant is an intermediary. He is required to collect the tax and pay to the government. In the first instance, if he has not collected the tax and recovered the tax from the consumer or the person to whom the incidence is really borne, it becomes the cost of his business. Unlike income tax, where the liability is on the person who is assessed to tax, in indirect taxes, it is always the principle that incidence is borne by somebody, but the person who is remitting the tax is actually at best doing an agency function for collecting the tax and remitting the government. Ideally, consumption taxes should be business neutral. Globally, that's the practice. So when we are talking about a time limit of 3 years or 5 years, in way 3 years becomes 4 years and 4 years becomes 6 years, 5 years becomes 6 years, mindful of the fact that it is not only the pain point for the adjudicating authority to ensure that the revenue interest is protected, but also look at the delay in timelines and the extension of adjudication also has a cost to the business in terms of the interest and penalty. Strike a balance, and that is where we are talking about timely scrutiny, timely audit, timely conclusion of investigation proceedings, and issue a notice, provide adequate timeline for the taxpayer to reply, provide adequate time limit to the adjudicator to decide the issue of appreciating of evidence, and pass a fair and judicious order, and thereby ensure the ends of justice is met. So what I am talking from this pedestal today is not only to talk about the pain points of an adjudicator, but look at the pain points of the taxpayer who has not collected the tax. So in a way, adjudication requires this broad-minded approach that you need to apply the law, you need to act within the four corners of the law. And therefore, when you pass an order, keep this perspective in mind that while revenue interest is absolutely supreme and what as proper officer we require to discharge it to correct, but the fairness in that approach is what is basically has to be kept in mind. In case of extended period of demand, it is 6 months and it has to be passed within that timeline. Now the question comes is with regard to suppression, willful misstatement or fraud. Fraud, as all of us understand, is basically collusion. There are two parties involved in the fraud. There is acquiescence to something has been happening on which a person has been a passive participant or an active participant. Insofar as suppression is concerned, we need to be very, very careful about it. A suppression of facts. What the word used is willful. The word preceding suppression is a statement is a willful. Suppression is something what otherwise you are required to disclose, you have not disclosed it. Now, in GST law, what is the comfort vis-a-vis the pre-GST laws? At least the officers from the central tax can appreciate this point better because they have seen in the central excise law. Now today what happens is your 3B is a summary return. Your outward supply in R1 is written at the invoice level. And fortunately for us today, most of the taxpayers above 5 crore threshold is on the e-invoicing, in which granularity with regard to the description of the product or the goods or services, the classification and the rate schedule applicable, and the applicable exemptions availed, everything can get into the invoice level detailing part of it. In addition to this, in GST law, like VAT laws, we do have an annual return. For those who are filing, whose turnover is below 2 crore, there may not be an annual return. But those above 2 crore up to the 5 crore, there is an annual return and there is a reconciliation which is to be matched with the books of accounts and the financial records. A lot of this information, insofar as the financial records are concerned, the way in which revenue is accounted for, an expenditure is reflected, the foreign exchange realization, foreign exchange expenses, in terms of what has been reflected in other books of account, in the books of account for other purpose of law like income tax, corporate law, other regulatory provisions, etc. A lot of information is required to be reflected in the annual return and the 9C reconciliation statement. So if you are alleging a suppression, willful misstatement or a fraud, it is incumbent on the department, when you are issuing a notice or for that matter when adjudicating, appreciate the point that how is that suppression or willful misstatement being articulated. A few of you have expressed difficulties with regard to the notice, and that's what I was discussing with Vinod Kumar sir just a while when this presentation was made. What we today talk about an adjudication workshop, perhaps I think those triggering events relating to the scrutiny, audit or investigation as to what should be the key ask in quality drafting of show cause notice is also equally important. Because in adjudication you are left with no choice but to decide a show cause notice. But what goes into making a good quality of show cause notice is another area of study for which I think I'm sure NACN and NLSA will take steps to bring some workshop for our office's benefit. But for the today's discussion, we will keep it to the adjudication limit. Adjudication is all about, when we are talking about suppression, willful misstatement or fraud, the onus of leading that there is a suppression, willful misstatement or a fraud is on the department. Once you make the allegation, we need to lead evidence to say how suppression, willful misstatement or fraud is proposed to be established in the adjudication proceeding by putting the noticee into response mode. So, in GST, alleging suppression, willful misstatement or intent to, fraud is more challenging than the excise law and the customs law. In excise and the customs law, still in addition to the suppression, willful misstatement or fraud, there is one more word which is very explicitly used called intent to evade payment of tax. What I think Ms. Manan talked about with regard to the mens rea is in the realm of the intent to evade payment of tax. GST law consciously do not make a reference of intent to evade payment of tax except section 132 which deals with prosecution. 132.1 subclass A to D talks about situations where there could be a mens rea, but that has to be read in conjunction with the provisions enshrined in 73, 74, 69, 70, etc., etc. So otherwise, for demand provisions under 73, 74, there is no intent to evade payment of tax, unlike the excise law and the service tax law, for that matter, customs law. So we have to establish in GST show cause notice at least a reasonable proposition that there is a suppression, willful misstatement or the fraud. And I told you the challenges what will arise on account of the annual return being filed, the granularity of the information already available to the department is required, and mechanically 74 should not be issued. And that was the instruction came in NOIC. And hopefully I think that will also get reflected in the circular in the days to come once the law committee approves it. But what is important is how do we look at that secondment of the employee? I'm just giving a flavor of what could be the challenges in adjudicator. A secondment of an employee can happen on a model where an Indian subsidiary completely reimburses the employee cost to a foreign company in a total manner. Foreign exchange expenses. You can audit it and find out in your books of accounts. The second model could be, insofar as the second employee to India is concerned, the Indian company makes the payment in INR and accounts for it for the tax deduction purpose in India, but remits a part of the social security which is required to be remitted to the home country where the employee continues to be a foreign company's employee in foreign expenses. There could be a third scenario where, including the social security, the social security part of it is given by the foreign company, the employee salary is given by the Indian subsidiary. Now, after NOS 141 ruling, still people have gone to the court and got at least in 3 or 4 high courts stay against the demand, even after NOS has come, distinguishing the facts. So now, even where a matter has been decided by the Supreme Court, which is binding on everybody, depending on the facts, there could be different views coming in, and high courts have just not trigger happy stated, because they have also made submission that in this case, my case is different from NOS. Now, be very careful and watchful when you are invoking suppression, willful misstatement, or fraud. The onus is on us to establish clearly and write a para. Many a times, what happens is simply reproduce the section and issue a notice, and that is where we will give in a walkover to somebody to challenge our proceedings. The last part of the adjudication, keep it in mind that you can't travel beyond the show cause notice. In adjudication, you can't make out a new case. This is one of the very, very fundamental principles of quasi-judicial decision making, that you cannot travel beyond the show cause notice. Show cause notice covering the allegations, covering the quantum of demand, covering the violations, you can't travel beyond the show cause notice. If you go beyond the show cause notice, then it's a problem. What could happen is, this is where all of you need to keep it in mind, particularly for those in the GST. The show cause notice issued under 7374 is issue specific. It is not period specific. Though the timeline for 3 years, 5 years, as the case may be, has been done, there is no bar in the law for issuing multiple show cause notices for the same period, provided you are covering different issues. It could be other matter that multiple show cause notices can be combined into and passed one single adjudication order, there is no problem. Or multiple adjudication orders can be combined into an appeal proceedings and resulting in a single appeal order passed. But what I am saying is, if you find that during adjudication you come across that certain omissions have happened for which notice has not been issued, subject to the availability of time limit, you can always tell the original authority to examine this issue and issue a show cause notice. Or, if comforts are there, withdraw the show cause notice which is deficient and issue a new notice within the time limit and adjudicate it in all. But don't go to adjudicate a matter on which show cause notice has not put the others into a notice. All that my advice is that. The second part, once you pass an adjudication order, the law presumes that you have exercised the power and you conclude and rest there. What we call it as functus officio. That means you are completing your process. You can't revisit your adjudication order. There is a detailed procedure under section 161 for rectification. What can be rectified and what cannot be rectified is also very clearly laid down on the law. I want all of you to appreciate that what is possible in a rectification of mistakes. I think please do ask Mr. Natarajan when he comes in the afternoon for a panel discussion as to where are the situations in which you can do an ROM, where are the situations you can't do an ROM. A mistake apparent on record alone can be corrected. It could be a typographical error, it could be an obvious omission which can be seen by the barren eye. There is no interpretation, there is no deep diving onto the facts. That if there is such a mistake, you can do a rectification within the time limit prescribed. But you can't re-adjudicate the matter, you can't reappreciate evidence, you can't pass a fresh order on the garb of rectification. Please avoid that. Because what is apparent on record has a huge jurisprudence in terms of up to Supreme Court what has been done. So this is one thing. The last part before I conclude is with regard to adjudication, is that GST law provides a timeline within which a remand order has to be decided. The GST law says that it has to be within 2 years from the date of remand, you have to pass an order. There is no such time limit in the GST excise law, or there is no time limit in the customs law. All that what we have in those laws is that the authority who has passed an order alone can do the remand adjudication. It cannot be a lower level officer because of the financial powers enhanced or whatever it is, consequent to that long passage of time. But GST law mandates it very, very clearly that you need to pass a remand order within 2 years from the date of remand. If you don't pass an order, there is a risk that it can just be set aside in appeal proceedings. Though the law doesn't clearly say if you don't pass within 2 years, it shall be deemed to have been closed, but it is directory in nature. The law says it has to be passed within 2 years. So remand proceedings should also be concluded within 2 years time limit from the date of remand. Thank you very much.